Hi, I'm an idiot with a YouTube account. I'm not a lawyer. I'm not an expert in the material subject here, or at least I'm disclaiming any knowledge of it. I am doing this based on the citations below that lead to various websites that are places that, quote unquote, should know the correct answer. I'm deliberately avoiding using legal sources for a simple reason. I want you to look this up through the local sources you have in your area. As stupid as this sounds, for the laws in your neighborhood, city, county, state, and country governing the purchase and use of anything or regulating it for any reason, go find a local lawyer that has to know these things and will sign an affidavit saying that they've actually learned this stuff and make them give you citations too, and then ask your local law enforcement agency as well, unless they're the kind of agency that will take you out and shoot you for asking them questions. I am an idiot with a YouTube account. I'm not a lawyer. Second time I've said it. Next, I'm going to be wrong depending on if you're like literally 4 miles east of me. I'm not joking. Here we go. Body armor laws do not violate Second Amendment right to keep and bear arms because they're not firearms or weaponry. Next, it's safety equipment. Next, virtually everywhere in the United States, unless there's some extenuating circumstance, it's not illegal or even regulated for you to have it. Now, very important thing is on a federal level, virtually all federal laws are under a weird presumption in the United States that they involve interstate commerce or interstate transactions or shipping, anything across the state lines is federal. States can regulate, outlaw, or ban from use, possession, or owning or constructing, or even discussing anything they want to. You have the right to redress, to complain, and get rid of those laws. Federal laws that are based on interstate commerce do not have the ability to apply under this very narrow definition. This is the best practices. If no component was made, shipped, sold, altered, manufactured, remanufactured, or fitted outside of the same state that you're in. Now, this is based on territorial laws taking precedent in commerce. That's literally the thing. And it doesn't matter if you bought or sold it. Even if the exchange was non-monetary, it's a physical exchange of items one way, doesn't have to have a reciprocal going the other way like money. It's an exchange of material between two individuals. If it crosses the state, that's shipping and receiving of it. There's not some presumption you're making money. It's considered potentially under commerce. You can DIY from local sources to make, keep, and bear anything. But again, the Second Amendment doesn't apply to something that isn't a firearm. And it's not about, Second Amendment to keep and bear arms has nothing to do with regulating, making, or altering. It's just it's an amendment, not part of the original framers' rulings. Ballistic protection considered for military usage, or being considered for military usage, may be forbidden to the civilian population or not at the time. That is up to the government to decide, because they're allowed to regulate anything that is to be used for military only, or is being proposed for it. This is actually a subset of the rule set that's in place, and has to do with the maintenance of the supply chain for the U.S. military and during war effort. So they have dibs, and they have the right to restrict or limit or whatever. To take, ship, send, or bring certain items outside of the U.S. or importing them may require, or usually requires, a federal permit, because they choose to make it to where they have their nose in your business, and that's it. Any attempt to get around these kind of rules is considered de facto proof of intent to violate a federal act, a federal law, and or usurp their authority. It doesn't matter if you actually committed a crime. It may seem that you're trying to. Intent is more important than the actual act in some cases, depending on how they wish to enforce it. And immediately people are going to cat-lag type that the federal government doesn't have any rights because I say so. That's not how the fucking world works, and we're not even going to discuss that. Now, if you're a felon of a violent crime, with only certain exceptions, you are more regulated than anybody else for the rest of your life. Now, exceptions can be granted, like restoring your rights, or more accurately, that's for Second Amendment, or removing restrictions on you because you committed a felony on paper, or you copped a plea to an upper level punishment with a very short sentence, the implication being that you weren't really guilty, but it was classed that way for technical reasons. You can request at the time, if you're copping a plea or whatever, to not have certain restrictions placed on you because it's an inordinate burden and it's not appropriate. If you were, quote, involved in a violent felony, but you didn't commit any violent act, but you're technically considered part of what caused it, but did not have knowledge of it, you can cop to the higher, not the lower, but the higher charge with a virtually non-existent sentence or a chopped sentence, with the understanding you really weren't involved, and request that they make note of that so that you can have your rights restored. We're talking about gun rights, but in this case, we're talking about anything. If you're a felon, you can be restricted from, it doesn't matter if you did anything involving anybody of that age group, being a teacher. You can request that that information be, well, not expunged, but sealed, because it would get in the way of you doing your job later, because you were involved in something over in this state, but it did involve something that started at a school or college. There are weird circumstances where you can request that simply because it's not appropriate to apply to it. A blanket application of, I'm a felon of some sort, therefore a bunch of rules kick in, is done just because, unless otherwise noted. Extenuating circumstances exist, including, and this is a weird one, you're a felon, but you really didn't do anything that deserves to be declared a felon, and you get a job working as a cop. And I'm not kidding about that. There are places in the United States that will grant you an exception because you are technically a felon, but you didn't commit a violent crime, but under federal law, it's listed that way. So you request that the federal government acknowledge that it was an inappropriate application of you being restricted from wearing body armor, safety equipment. Yeah. Another one is, I want to work as a locksmith. I have to have lockpicks. If I'm guilty of a federal crime for hacking, even if it was productive hacking and it was a good thing, legally speaking, they have to prosecute me. They'll give me a 0-day sentence, which is kind of funny because 0 day is actually something we talk about in geek world. But they'll state that you're a felon after that point, and I can say, I'm not a felon in that way. I didn't do anything violent. You can't restrict me. Well, why do you want to do that later on? Are you planning on doing something wrong? That's presumption of guilt. If I'm convicted of something and it's clear that it was me using a computer inappropriately, you can restrict my access to the internet or a computer, or try to. But telling me I can't wear a bulletproof vest because I'm working at Denny's and it's a bad neighborhood isn't acceptable. Or saying I can't work at a bank. I'm not kidding. There are felons who are right behind that counter working as a teller, because it's your admin keeping people from breaking into the computer system. There's a shit ton of computer hackers in the United States that are dead-ass felons. They're really guilty of some shit, but they turn state's evidence and they agree to be declared a felon for a short time, and then it's removed. And it stays on their paperwork, but they carry a sheet of paper saying, I was declared a felon just to make sure I wouldn't break a law, so that I go immediately to prison. Been good, and now I'm running, well, Norton or something. You're not supposed to restrict people that way. That's inappropriate. And also, it's not applicable. Other things. I can ship and receive stuff. Well, if you're running a shipping and receiving location, you can't do it if you're a felon because someone might ship something illegal through that location. That's not acceptable. That's overreach. And that's acknowledged. But let's continue. Laws that strive to keep a felon or a misdemeanor convict that's escalated to felony, it depends on your area, from owning anything that will facilitate a future crime are premised on presumption of guilt in the future, that they will commit a crime. This is why these laws do have exceptions and allow petition for relief or removal or a time limit, which is not something the federal laws cover, but they do, but they don't want to include it. By the way, some of these exceptions were created for military people. They would be guilty of a felony, and they would be given a time where the more extreme version of the military's version of what a felony is would disappear on the civil level. But on civil level, you would be declared, a massive, horrible criminal for 5 years, and then after that, it would be removed from your record, and you'd have to spend 5 years being a very good boy. Basically, it means that after you're convicted and released, it's a de facto probation period where you have a parole officer kind of a situation, except you don't have a parole officer. You don't get out until they say so, and you can't appeal to leave. And then when you're in civilian life for 5 years, you're declared to have committed a felony. That's it. It's just to make sure you stay honest 5 years when you're in civilian world, and you're never allowed to be in the military again after you get out of whatever prison they have. There's only a few things they'll do that with, but eventually you're declared to have paid your debt to society. That's what it's based on. Deciding to put on body armor and deciding after, specifically, or before, it doesn't matter, to commit a crime and or deciding to commit a crime and ending up being involved in a crime says a lot about the defendant's intent to break the law and minimize the chances the law enforcement can stop them, or they're worried about getting injured. Depending on the intent, if you're just, I'm wearing body armor because that's what I have, but that's protection against impact. That's an actual case where someone said, I wasn't wearing body armor to prevent the cops from hurting me. We're raiding another mob location. It's still technically a violation that should be added on, but the person was given an exemption and said, no, you weren't wearing body armor with the intent to commit a crime. You were wearing it just to keep yourself from being hurt by others because it's a gang war. Those are very, very weird exceptions and exemptions. But except for that, in general, if you're a felon, you cannot wear body armor, can't have a gun, etc. But again, with some exceptions, you can apply to have those restrictions removed and permanently barred from being applied. Laws that enhance the sentencing for a crime committed while the defendant was wearing body armor do make sense, however. And again, I'm repeating this. Body armor laws, federal or state or county, or whatever, do not have anything to do with your right to keep and bear arms. They're safety equipment. You can't make that argument, and every time you do that, you're allowing the government to say de facto that anything can be called under the same ruling as a firearm. You're opening a door you won't be able to shut. Don't do that. Again, if it's military usage or military preferred or military purposed anything, it can be restricted from civilians unless they claim to be part of a disorganized or organized militia. And that's another can of worms. But yes, in some states they have a militia rule, which means you have to declare yourself to be part of the National Guard or a local militia. There's only literally a few towns that have a local militia because they don't really have police. Most of these are out in the middle of nowhere, and basically everyone's part of the militia, which means you're allowed to or encouraged to use weapons that would normally be weapons of war, which means you have to have an assault weapon or an assault rifle. Again, there's only one or two of them I heard of, and they don't ever use that activity. They don't ever involve that. But they're allowed to, so they have literally an armory with real fucking machine guns at a gun club. That exists. These are locations that were actually invaded or attacked at one time, most of them on the East Coast. And, well, except that it's really only applied in foreign-controlled locations by the United States or possessions where they actually experience shit, which means the entire population is declared to be military, if they want to be. You have to have a gun if you're in some parts of the world. It's American-held. It's under siege. Next. If you must wear body armor because of your job and you obtain an employer prior written certificate and its non-criminal intent is obvious, then any rules regulating you are usually thrown out because you are de facto registered. You are listed. You would have to have a federal permit or a county or city permit. Next. Federal laws based on interstate commerce, again, do not apply if no part was made, shipped, sold, configured, whatever, outside of the state. You can DIY from local sources almost all of this. Some states even make such an extreme exemption that they will tell the federal government the person is declared not to be a felon because the felony occurred in circumstances we've granted this person exemption to. As long as they don't leave the state ever, they can't be arrested. Once they leave the state, the federal government can arrest them. That's, again, very rare. States can regulate, outlaw, ban, or whatever, use, possession, owning, or being near anything. States' rights. Unless they violate their own constitution or the federal law. And again, body armor doesn't fall under that. Neither does grenades. Schools may have a restriction on them of no one coming on the property with anything even resembling a BB gun. These are rules that you are not allowed to argue with unless you do it correctly. You might be required a permit and de facto registration. They may criminalize misuse of it, enhance sentences when armor or whatever is used in commission of a crime, but most states don't regulate any form of body armor and allow anyone to wear body armor anywhere because it's safety equipment. And if you DIY it, it forces the federal government not to have any control over it at all, especially if you do nothing but local material. And yes, if you live in a state that has a company that makes Kevlar fiber for other purposes, making body armor this way is not illegal and would be exempt from federal control. Again, I'm an idiot on the YouTubes. I am not a lawyer. Talk to a lawyer first, then the local authorities about anything. Body armor is an example in this case. Anything federal regulated may have the same rules. Thanks for watching. Have a good day. Good luck with it.